Hanacho. That is Hanacho.
Aloze is ALOZI, right?
Yes, my lord. ZIE.
ALOZIE. Okay.
Yes.
Adijat, the defendants are not in court. Registrar. Okay, defendants not represented.
As a court prisoner.
Okay, so this is the judgment of the court. Between Melvin John Odili, the claimant, and Water Solutions DWC LLC, and Sebastian Walter as defendants. So by general form of complaint dated and filed on the 7th of September 2023, the claimant seeks the following reliefs. One, the sum of 46,925,000 euros being the sum due to the claimant as earned commissions for sales as of January 2023. Two, the sum of $6,000 being the claimant's unpaid salaries for February and March 2023. Three, interest on the sum of 46,925,000 euros and the sum of $6,000 at the rate of 21% per annum from the 31st of March 2023 until judgment is delivered, and subsequently at the rate of 18% per annum from the date of judgment until final liquidation. The sum of 16,000 euros being the sum due to the claimant as earnings for stock gaps for sales as of January 2023, and the sum of 2 million naira being the costs and expenses incidental to these proceedings incurred by the claimant. The claimant's case is that he's a Nigerian citizen who was employed by the defendant as a regional sales manager based and resident in Lagos on the 2nd of April 2021 to market and sell BBM extrusion blow molding equipment across West Africa. He was in charge of the work of the following markets: Phase 1, Nigeria and Cameroon, and Phase 2, Nigeria and Ghana, Phase 2, Senegal, Ivory Coast, and the Cameroons. The claimant averts that the first defendant, based in Dubai, United Arab Emirates, is an authorized agent of BBM Maschinebois GmbH Germany, while the second defendant is its general manager and the claimant's immediate supervisor, that the salaries and commissions were dominated in US dollars and euros, and communication between the parties were mainly through email. His remuneration package included: one, salary of $3,000 per month, culminating in $36,000 per annum, 0.5% on 5% commission on machine sales, and 20% 20-day paid vacation per annum. By a notice of resignation dated the 3rd of January 2023, effective on the 31st of March 2023, the claimant averred that even though he worked from January to March, his salaries for February and March 2023 were withheld, but he admitted that he was paid for January 2023. The defendant also failed to pay him for the 6,929 euros as commissions for prior year sales already admitted via email, and 15,000 euros as stock gap performance incentive also acknowledged by the defendant. The claimant's efforts and that of his counsel via demand letter dated August 2nd, 2023 to recover these sums were ignored. Instead, the defendant allegedly made false allegations of fraud and breach to avoid paying him. Claimant tendered 8 numbered documents to be used at the trial, which were admitted and marked as Exhibit C1 to Exhibit C8. It's all listed in the body of the judgment. On commencement of proceedings, the defendant did not enter appearance and did not participate in the trial proceedings. Defendants were duly served with all the processes and hearing notices. The claimant, as CW1, adopted his written deposition on oath dated the 7th day of September 2023 on the 16th day of October 2024 as his testimony and evidence in this case, and was not cross-examined by the defendant counsel. On the application of counsel to the claimant, the defendants were foreclosed and CW1 discharged from the witness box on the 25th day of February 2025. The records of the proceedings of the court bear it out that several adjournments were granted to enable the defendants file their defense and cross-examine the claimant. The defendants were served with hearing notices with respect to the scheduled hearing dates. In spite of the adjournments, the defendants failed to avail the opportunity to defend the case. The court foreclosed the defendant from its defense and adjourned for adoption of final written address. The claimant filed his final written address, and the sole issue for determination was whether in all the circumstances of this case, the claimant has by cogent and credible evidence established his entitlement to the reliefs claimed in these proceedings. I'm going to skip the addresses and go to the court decision. Now, the legal implication of the failure of the defendant to call evidence in defense of the claims is that the defendant is presumed to have admitted the case made against it by the claimant. See Oko Ebo versus Police Council and Ifeta versus Shell Petroleum Development Corporation of Nigeria. Citations are all provided. The law, however, is that this does not on its own translate to automatic victory for the claimant against the defendant. This is because the claimant must succeed on the strength of his case and not rely on the weakness of the defense and the absence of a statement of defense or evidence by the defendant does not exonerate the responsibility on the claimant to prove his claim. See Haka Air Services Limited versus Kezio and Ogunyade versus Oshukeye. Citations are all provided. It is a universal evidential principle that he who asserts proves his assertion. He who claims proves his claim. It is needless to cite authorities for this well-known principle. To establish that he was an employee of the defendant, the claimant in his testimony referred to his letter of offer of appointment, which was admitted and marked as Exhibit C1, employment agreement dated April the 2nd, 2021. A cursory look at the employment agreement indicates that it was endorsed by both parties with the commencement date of 26th of April 2021. It contains 14 subheads ranging from the position, place of work, responsibilities, markets, contract start date, salary, commission, medical insurance, holidays, termination, outside employment, competition after leaving the company, confidentiality, and other agreements. From the email trails exhibited by the claimant, such as Exhibit C2, Exhibit C4, and Exhibit C5, there is ample evidence that the claimant was in the employment of the defendant. And in Nigeria Airways versus Gbajumon, the court held, citation provided, the court held that where one party employs another, appoints him to various positions in this establishment, pays him salaries and allowances, this acts constitutes sufficient fact from which a contract of employment can be inferred. I so find. The claimant is before this court seeking the sum of 46,929,000 euros, being the sum due to the claimant as earned commissions for sales as of January 2023. The claimant avers in paragraph 6 of his statement of fact that as of January 2023, when he submitted his resignation letter, he was entitled to this sum, being the sum earned as commissions for sales in the previous year. According to him, the sum is already admitted and agreed to in the email trail dated January 9th to the 29th, 2023, which was marked and admitted as Exhibit C5. The terms and conditions of contract of service are the bedrock of any case and should therefore be pleaded. In Corey Lighter Age versus T and GWO citation provided, the court held that it is usual to speak of the terms and conditions of employment, which are part of every contract of employment. Terms of employment are bilateral, that is, they are part of the agreement made between the employer and the employee, and terms of employment can be found in all agreements, whether express or implied. It is also tried law that parties are bound by their terms of contract of employment, particularly where the terms are clear and unambiguous. See Union Bank Nigeria versus Suarez, citations provided. In the instant case, Exhibit C1, which is the employment contract, has in subhead 7, and I quote, commission, 0.5% of all machine sales value unless mutually agreed otherwise. A, equipment value, Euro 3 MIU equals to commission of 15,000 euro. B, equipment value euro 5 MIU, the commission is 25,000 euro. This term of the contract provides for commission as shown above. The claimant is relying on the email thread to justify his claim that what the court noted from the said email thread is that on Monday, the 9th of January 2023, at 10:31 p.m., the defendant, Sebastian Walter, sent a mail to the claimant and copied Bernard Schweit. And the subject of the email was commission. The message was, and I quote, "Hi, Melvin, please find below overview. Add over 49329 euro 1,000 euros, goods value euro 200,000 euros. TGI 49610 9,175 euro, goods value 1,835,000 1,835 euros. AA Rano 49357 1,575 euro. The goods value equals 315 euro. As per original work contract excluded, will however be included tentative, not all costs confirmed. The email goes further. Add over 5,300 16,000 euro based on goods value of 3,200 mil. Hilorio 5,066 euro, 9,625 euros based on goods value of 1,925 euro. Hilaru 569 euro 9,550 euro based on goods value euro 1,910 MIU. Best regards, Sebastian. End of quotation. The follow-up email was from the claimant on the 10th of February 2023 at 7:25 to Sebastian Walter and copied to Bernard Schultz. Dear Sebastian, dear Bernard, thanks for your feedback. I had assumed that I was also entitled to some commissions for stock gap also. Best regards, Melvin. In response, Sebastian Walter replied same day, 10th of January 2023 at 10:54, 4:33 seconds AM and copied Bernard Schultz. And I quote, "Hi, Melvin. My apologies. I forgot stop gap in the list. Will update this afternoon. Best regards, Sebastian." It is evident from before this court that the claimant has been able to establish that he was entitled to commission as agreed by parties in the employment agreement in Exhibit C1 and in Exhibit C5, going by the email trail. The defendant, in the person of the second defendant, admitted to the fact that the claimant is entitled to commission in the sum of 46,925,000 euro. That is in bracket 1,000 euro plus 9,175 euro plus another 1,575 euro plus another 6,000 euros and plus another 9,625 euros and another 9,550 euros. The total is 46,925 euros. This is the finding of the court. Relief 1 succeeds, I so hold. Now, the second relief is for the sum of $6,000 US, being the claimant's unpaid salaries for February and March 2023. The claimant, in his statement of fact, averred that his remunerations and salaries were dominated in US dollars and euros. That after he served the defendants his 3 months notice period prior to resignation, dated January 3rd, 2023, in compliance with the employment contract, he was paid salary for the month of January 2023 only and was told to offset the February salary with the monthly expenses for the month which did not cover the entire salary. That the defendants did not make up the shortfall, whereupon the claimant informed the defendants via email that he will not be able to carry out any task insofar as his salary was not paid. Going by the employment contract Exhibit C1 in subhead 6, under salaries, and I quote, USD 3,000 per month. The salary is paid at the end of the month. 12-month salaries per annum. End of quotation. The claimant admitted that January's salary was paid, and by his averment, he was informed by the defendant to offset the February salary with his monthly expenses for the month, which did not cover the entire salary. The claimant failed to inform this court on the specific amount that was given to him for monthly expenses. Exhibit C1 has established the fact that 3,000 USD was his monthly salary. However, in paragraph 5 of the statement of fact, claimant stated that the defendant did not make up the shortfall, whereupon the defendants were informed that he would no longer carry out tax if he was not paid. The import of this statement is that monthly expenses was paid to the claimant, and he was instructed to use that to offset his February salary. If the claimant maintains that defendant did not make up for the shortfall, then going by common sense, some amount was paid to take care of the February salary. The said amount, for reasons best known to the claimant, was never disclosed to the court. The courts have always frowned and maintained that the court cannot speculate on facts. See the dictum of Ekpe JCA in Arum versus Ohafia Line Services Limited citation provided, where, and I quote, in the case of Adisa versus the state, citation provided, the Supreme Court held that what a court of law should do is make use of the available materials before it. And in this context, the affidavit evidence and come out with some figure which it thinks will satisfy the justice of the case. A court can only give that much that the evidence at its disposal proves. After all, a court cannot speculate or conjecture possible facts not before it, or dabble into or flirt with facts not before it. See also the cases of Beyong versus Nyong and Union Beverages Limited versus Owolabi citations were provided. End of quotation. In the light of the above, this court is not convinced that in the instant case that the salary for February was not paid. Some amount was paid as admitted by the claimant by his testimony. It is settled principle that the claimant's evidence must be credible and reliable and must be presented in a clear and convincing manner. The claimant typically bears the burden of proof, which means they must prove their case on a balance of probability, especially in civil cases. To the mind of this court, the claimant has failed by his own testimony to discharge that burden of proof. Therefore, this court shall decline to grant the first part of the relief, which is for 3,000 USD for February 2023 salary. I so find and hold. With regards to the second arm of relief B, of relief 2, which is for 3,000 USD as salary for March, parties are bound by the terms of the agreement. Exhibit C1 clearly provides that claimant's salary shall be $3,000. The claimant has maintained by his testimony that it was not paid, and he informed the defendant that he would no longer carry out tax for him if he is not paid the salary. This relief succeeds in part, and the claimant is entitled to 3,000 USD for March 2023 salary only. I so hold. The third relief sought is for the interest on the sum of 46,925 euros and the sum of $6,000 at the rate of 21% per annum from the 31st day of March 2023 until judgment is delivered, and subsequently at the rate of 18% per annum from the date of judgment until final liquidation. In SkyMed Nigeria Limited versus UBA citation provided on the distinction between prejudgment interest and post-judgment interest, the Supreme Court held that prejudgment is simply a judgment reached before evidence is available. If the claim is for money, the claimant may claim interest up until the date the judgment is given, and that is pre-judgment interest. There is a clear difference between an award of interest per pre-judgment. I'll take that again. There's a clear difference between an award of interest pre-judgment, where a plaintiff must specifically claim such and prove it, and award of interest on a judgment debt, which is purely statutory and can only be awarded if there are provisions to that effect in the law or rules of court. Ekunife versus Wayne, Belite versus Kachala, citations were provided. It was Rose Bible, JCA, as it then was, relying on Okunife versus Wayne, Texaco versus Petma, Nigeria Limited, Habot Plasticine versus Wayne Tank and Pump Company Limited, and AB Kempt Limited versus Toland, who took time out to expound on the position of the law on the vexed issue of prejudgment interest in the following words, and I quote, "When actions are brought on commercial matters, the court usually find that money ought to have been paid some time ago. In such cases, it ought to carry interest, and that is prejudgment interest. The time prejudgment when it will start to run depends on evidence. The basis of such an award is that the defendant had kept the plaintiff out of his money, and the defendant has had the use of it for himself, so he ought to compensate the plaintiff accordingly." I continue with the quotation. "The general rule at common law is that prejudgment interest is not payable on a debt or loan in the absence of express agreement or some course of dealing or custom to that effect. Thus, prejudgment interest will be payable where there is an express agreement to that effect, and such agreement may be inferred from a course of dealing between the parties, or where an obligation to pay interest arises from the common practice or usage of a particular trade or business." Alpha 3 Nigeria Limited versus Attorney General of the Federation, Diamond Bank versus Partnership Investment Company Limited. End of quotation. Consequently, a plaintiff, in order to succeed in a claim for prejudgment interest, must show how the entitlement to such interest arose. That is, whether by law, by contract or agreement, or he must plead facts showing that the claim is part of the loss or special damages which the defendant's wrong imposed on him. It is not enough to merely say that the plaintiff is claiming interest. The basis of the claim of interest must be made manifest on the pleading. See Ekunife versus Yen Supra, Sani Abacha Foundation for Peace and Unity versus UBA, Per Abiru JCA. In the light of the foregoing authorities, it is without doubt that the claimant presented no scintilla of proof that there is either an agreement for 21% interest or statutory provision imposing the payment of the said interest on the sum awarded to the claimant in relief 1 above as prejudgment interest. Consequently, the claimant is not entitled to prejudgment interest, and same is accordingly refused. I so hold. With regards to post-judgment interest, on the other hand, 18% per annum from the date of judgment until final liquidation. I take into cognizance the provisions of the rules of this court, which by Order 47 Rule 7 stipulates that the court may, at the time of delivering judgment or making the order, give direction as to the period within which payment is to be made, and may order interest at a rate not less than 10% per annum. Relief 4 is for the sum of 16,000 euros, being earnings for stock gaps for sales as at January 2023. In paragraph 8 of the statement of fact, the claimant states that he is also entitled to remuneration called stock gaps, which was given to him as a performance enhancement incentive. That the defendants acknowledged that he is entitled to this to same in the several emails exchanged between the second defendant. In Exhibit C5, there is an acknowledgement by the defendant that the claimant is entitled to stock gap in his email of 10th January 2023 at 10:54 a.m., which was also copied to Bernard Schultz. And I quote, "Hi, Melvins. My apologies. I forgot stock gap in the list. Will update this afternoon. Best regards, Sebastian." The court noted that parties are in agreement that claimant is entitled to stock gaps, going by the claimant's reminder that it should be included in his calculated entitlement and the defendant's acknowledgement. However, both parties were silent on the specific amount and how it was calculated. What the court has before it is just a blanket acknowledgement that the claimant is entitled to stock gap. In view of this court declines to award 16,000 euros being sought as earnings for stock gaps for sales as of January 2023. I so find and hold. Relief 4 fails and it is dismissed. The fifth relief is for the sum of 2 million, being the cost and expenses incidental to these proceedings incurred by the claimant. Costs and expenses incidental to this case is assessed at 400,000 naira only. I so hold. All sums awarded in this judgment is to be paid within 30 days of the judgment, failing which it will attract 10% simple interest per annum. Judgment is entered accordingly. So this is the judgment of the court between Melvin John Udili and Walter Sebastian DWC LLC. Khadija, are you ready to call the other cases?
Yes, my lord.
Okay.
My lord, the next one is NICN/LA/77/2022 between Ms. Obiangeli Obi and Nigerian Chamber of Shipping. Hello, is your plate on? Eh?
Who is in court?
Parties absent, right?
Parties absent?
Is the claimant? No.
Khadija, are parties in court?
No, my lord. No,
Okay.
my lord. Parties absent.
Parties absent.
My lord, the claimant is online.
Okay.
But the defendant is not represented.
Okay.
That's my lord.
May you please B.A. Adesoji for the defendant. And I'm with S.O. Pampa.
B.E. Ade Soji for the defendant.
For the, yes, S.O. Pampa.
Say that again. Can you take the phone closer to you?
S.O. Pampa.
Okay. For the defendants too.
Yes, my lord.
The claimant's counsel is in court.
Yes, sir. I've announced
I
my
didn't hear
appearance. Caller Akoshi for the claimant.
caller Akushili.
Yes, sir.
Okay. All right. We can go ahead then.
Yes, my lady. The matter is supposed to be for report of or trial.
Okay.
However, the defense have a motion before the honorable court. I will allow them continue.
Mr. Soji.
Yes, madam, we have a motion dated the 19th of November 2025 seeking to
Hold on.
another of this honorable court to reopen the claimant's case by recalling the claimant's sole witness for us to cross-examine the witness.
Hold on. Take it easy. I'm writing.
Okay, sorry, my lord. My apologies.
So your motion of notice is dated when?
19th of November 2025.
Okay. Seeking
Yes.
to?
Is seeking an order to reopen the claimant's case. And recall the claimant's witness on record, that's CW1.
Okay.
For cross-examination by the defendant.
Okay.
And subject to the court's convenience, we are ready to move the motion.
Okay. Mr. Koshile, were you served with this motion?
Yes, we were served, sir, and we don't have any objection to the motion.
Okay, just a minute.
Yes, sir.
Please just give me 2 minutes. I'll be back.
As a copy. We should meet it. Okay.
Hey, Mr. Koshile, you say you have been served and you have no objection, right? Hello? Hello?
We have no objection, my lord.
Okay, then. Application granted as prayed.
As a copy.
Okay. All right.
Yes. Okay, so my lord, in that light, we shall be praying the court for a date for the continuation of trial.
Okay. Register.
She said a phone, so she can't take it.
Adijat,
Yes, my lord.
can we have a date?
My lord,
9th of what?
9th, my lord.
9th January.
9th 1902. 1902.
Okay, 19 February 2026. Yes. For continuation of trial. Okay, case adjourned to the 9th of February 2026 for continuation of trial.
19th of
Sorry,
February,
my lord.
my lord.
Is it 19th or 9th, my lord?
Registrar, what did
Is
you say?
19th the registrar said?
19.
19, my lord. Yes,
Yes.
Okay then. Okay, good. So case adjourned to 19 February 2026 for continuation of trial.
As
As
the
the
court
court
pleases.
pleases.
Okay, thank you. Adijat. Registrar, what's the next?
NICN/LA/25462 between Jean Marine Latari and Warstrand Aviation Limited and one another. My lord, parties absent.
Okay.
May it please the court. CC Ikenna. I humbly announce my appearance for the claimant.
May it please the court. I am Olabode Shoduke. I humbly appear for the defendants.
Okay.
My lord, the matter was adjourned for adoption of final written addresses.
Okay.
But unfortunately, the defendant's final written addresses has not been filed due to health challenges on the part of the counsel. I have informed the claimant counsel of this predicament, and have begged that we would file unfailingly on Monday. In light of that, I'm humbly applying to the court to give us another date to adopt the final written addresses. I sincerely apologize on my part, and undertake that we will file our final written addresses on Monday, 1st of December, unfailingly.
Claimant counsel.
Respectfully, sir, that's the position, sir. And I have no
Okay.
objection to the application, sir.
Registrar, give us a date quickly.
Convenient.
Registrar. Registrar. Okay, can we get a date?
No. 13th.
My lord, 13th January.
Convenient, sir.
It's convenient for the defendant.
My lord, my lord,
The registrar, can you hear me?
yes, my lord.
Okay. Can we get a date?
13th January, my lord.
It's convenient, sir.
13 January.
13 January.
It's convenient
When
Yes,
are we
my lord.
when are we resuming?
My lord, on 8th January.
Is that the first day of sitting?
No, my lord, the first day of sitting is 14th January,
Okay.
and 13th is a Tuesday.
Is it 12 to 13? I said 14 January. First day of sitting.
The first day of sitting is 14th. Is that what I heard?
Yes, my lord.
Oh, okay. And you are giving them what day?
13th is a Tuesday.
Well, the court is not sitting on Tuesday then. The court will start sitting on the 14th. Is that not what you're saying? Do we have
My
any
lord,
matter on, do we have any matter on the 13th?
No, my lord.
And 13th is a Tuesday.
Yes, my lord.
Okay. Is it convenient to cancel?
Yes, my lord.
Yes, my lord.
So case
Yes, my lord.
adjourned to 1-3 January
Yes, my lord.
As a court, please.
2026. Okay.
For adoption
For
of final
adoption.
written please.
Okay.
As a call, please.
Okay.
I'm most grateful to the court.
Most grateful, sir.
Okay.
Thank you very much.
7. Okay, so case adjourned to 1-3 January 2026 for adoption of final written addresses.
As a call, please.
As a court, please.
Okay. Okay, call the next case then.
Yes, my lord. NICN/L8/125/2025 between Mr. Kayode Elu Sakin and Dot HMO Limited and another. My lord, parties absent.
My lord, Seriki Abidin for the
Just a minute.
claimant.
Just a minute. The name again?
Seriki Abidin for the claimant.
Spell the surname.
SERIKI.
I got that.
Abidin.
Spell that one.
ABIDWEN. My lord,
Okay.
it's a new
And you're for the
matter.
claimant.
Yes, ma'am.
Okay. Is the defendant represented in court?
No, my lord.
My lord,
Okay.
at the last adjourned date, we informed the court we have served the defendant. It was adjourned to October, but the court did not sit.
Yes.
We want to inform the court we are ready to proceed to trial.
Okay.
We also want to inform the court.
Are you ready to
Yes,
proceed to
my
trial?
lord.
Yes, ma'am. Defendant have not filed their defense.
Pardon?
Said the defendant have not filed their defense.
Yeah. So what do we do?
We want to proceed to trial, ma'am.
Okay. So Khadija, give us a date quickly.
Yes, my lord. My lord, 25th.
25.
My lord, 5th March.
05 March.
Yes, my lord.
Is it
Convenient,
convenient
ma'am.
to the claimant counsel?
Convenient, ma'am.
Okay.
Thank you, my lord.
Okay. So case adjourned to 05 March 2026. Hearing notice is to be served on the defendant and profile in the case file.
Thank you, my
I prefer closing.
lord.
Khadija.
Yes, my lord.
Okay. What's the next case?
NICN/LA/375/2019 between Mrs. Muinat A. Murtodo and Nikon Insurance Limited. My lord, claimant present, defendant not represented. What? The link. These are the cost list now, I told you. It's not there.
Respectfully, my lord.
Hold on, claimant in court, right?
Yes, my lord, claimant present, defendant not represented.
Okay. Chimadu.
Respectfully, my lord, Chijoke Ukomadu.
Okay, Chijoke.
My appearance for the claimant, my lord.
Okay.
My lord, it appears that
Is
the
it counsel?
defendant's counsel is yet not in court again. And I sent him very much. I even called him. I sent it to his WhatsApp.
Khadija, did you send hearing notice to him?
Yes, my lord, they are aware of today's date.
My lord, they are aware. I also shared it to them personally, I called yesterday. My lord, about 2 or 3 weeks ago, I called the lawyer personally to inform him. I also sent the hearing notice issued to his WhatsApp, which he saw. I also called again yesterday. He was not picking my call. I sent it. I had called 3 weeks ago when I told him. He said he was going to be in court, that he was going to send me an email. I called again, I'm sure about 2 weeks ago, to remind him. I was providing almost as if it was weekly updates.
Okay. So let me, what I have recorded is I called defendant counsel personally 3 weeks ago to remind him. I also sent the hearing notice to the defendant counsel by WhatsApp, which he received.
As the court pleases.
Okay. All right. So what do we do? The CW is still in the witness box, right?
As the court pleases. I know that she's been called. She came all the way from Ikorodu.
Yes. Well, we'll take an adjournment, the last adjournment.
As the court pleases.
I'll take the last adjournment. Linda, give us a date.
Yes, my lord. My lord, 13th January.
So we shall be taking the last adjournment on this matter. Case is adjourned to the 13th, 1-3 January 2026 for continuation of trial. Hearing notice is to be served on the defendant and proof filed in the case file.
As the court pleases.
Claimant counsel, do you undertake to inform the defense counsel of today's proceedings? What did you say?
Come. My lord, yes, I undertake to inform him of the next hearing date.
Okay, thank you. Okay, I think I call the next case.
NICN/LA/15/2024 between Isaac Tony Ogidi and one Silsado Contracting Nigeria Limited, two Bridgeside Nigeria Limited. My lord, claimant present, first and second defendant not represented.
Appearances.
Where is it?
Counsel in court.
No, my lord. but the claimant is in court. He's saying that his counsel is sick.
Okay.
Yes, my lord.
So we'll take a date then. The
And
defendant counsel in court.
the defendants are not represented and their counsel is not in the courts, my lord.
Okay.
Yes, my lord.
Can we take a date then?
Yes, my lord. My lord, 25th February. 25 February.
Okay. The case adjourned to 2/5 of February 2026 for continuation of trial. Hearing notices to be served on all the parties and proof filed in the case file.
As the court pleases. NICN/LA/332/2024 between Ms. Adaobi Efibi and the Register Trustees of Banana Island Properties Owners and Resident Association and one another. My lord, claimant present, defendant not represented.
Appearances. Tell him to take the phone closer to himself. Adita, tell him to bring the phone closer to himself.
Okay, bring it closer to yourself, your phone.
My name is Ayola Julius. My lord, my appearance is for the claim, sir.
Okay.
May the court be pleased. Kehinde Awusu appear for the defendant.
Kehinde who?
Kehinde Awusu, my lord.
Can you spell the surname?
AWOSUSI. AWOSUSI.
Okay then.
Appear for the defendant.
Okay.
Yes, my lord. We have an application which is scheduled today. I've just been informed by my colleague here that they have a counter and they're just filing it.
So you have an
My lord,
application
it is
dated.
saying that my application is dated 11th November 2025.
Yes. When was it
And
filed?
I've been informed on the 11th, my lord, the 11th
Same day.
November. Yes, my lord. 11th November 2025, my lord.
Okay.
My Lord, Mr. Awusu just informed me this morning that they have a counter affidavit in reaction to this application. And they are just filing same today. So it's craving for a date, my Lord. My Lord, we have no objection to the application for a date. Thank you, sir.
Okay. Mr. Kende.
My Lord, I confirm the position of the claimant counsel. We intend to react to the application, and it's currently being filed at the court registry. So in the circumstance, we shall be praying for a date.
You don't give us a date then.
Yes. I'm sorry, sir. I wouldn't know that graciously indulge us for very short dates because this amendment was something I do on patience. You can come back next
I did not hear that. I did not hear that.
Yes, my Lord. I'm asking the court to indulge us with a short day for this application. Thereafter, we can get a day for the trial, my Lord. If it's convenient, we'll be grateful, sir. You can come back December. It's just for this motion, just for the application, my Lord.
So the application is the 11th of November. What are you seeking?
My Lord, we are amending our statement of facts. The application is for amendment of our statement of facts, sir. There is a document we misapprehended. We have changed it now. I don't want to form part of the record, sir. And I think that's all. It's not something serious, sir. Even if they have a reaction to it, it's not something serious.
Khadijat, what date can we give them?
My Lord, in December. It will be next week too. About 9. Okay, my 9th December.
9th of December.
Yes, my Lord.
Okay, you give them the court email. Let them forward all the processes to that email.
Yes, my Lord.
My Lord, I'm so sorry. 9th of December is not convenient for me.
I can't hear you.
My Lord, I'm so sorry. 9th of December is not convenient for me. Because I have a trial that day and I would not be able to make it to court. I'm so sorry, my Lord.
Okay. 9th is what day?
9th is a Tuesday.
Okay. How about Wednesday?
Okay. 10th is convenient, my Lord. We'll take 10th.
Okay. Go back to the Mr. Yola. Is 10th okay for him?
My Lord, is okay, sir.
Have you told them have you told them to send their processes to the email? Counsel, can you hear me? Hello?
I can hear you, sir.
Okay. Forward all your processes to the email. The registrar will show it to you. It's written on the witness box.
As a couple, we will do so, sir.
Okay.
We are most grateful. Just,
My lord,
I'm sorry, as a way of
I'm sorry,
clarification,
as a way of clarification, if it is all the processes filed by all parties, or just the application and the reaction
The application and the counter.
as the court pleases. We are much
Yeah.
obliged.
That's what we are dealing with on the 9th, on the 10th, isn't it?
Yes, my lord. We are much obliged.
Okay. So council is directed to send their process to the email case adjourned to the 10th of December, 10 December 2025 for further hearing of the application.
As the court pleases. My lord,
Yeah.
that will be all for today.
Okay.
Yes, my lord.
All right.
Court.
bá mi ṣe kí ní èyí, mo bó ṣe ń ṣe gbogbo àwọn nǹkan wọ̀nyí jàre.